Good afternoon, and thank you for joining us. My partner and I are here to discuss civility and professionalism. And my name is Kathleen McDormand. I am a partner with Ford and Ladner Gervais. I've been called to the bar in Nunavut since 2010 and thoroughly enjoy practicing in Nunavut. My partner is Odessa Odell. Her practice area focuses on labor and employment law, and we look forward to sharing with you for a few moments today. Now more than ever, law societies are stressing the importance of civility among lawyers, and it is crucially important in our roles to remember that professionalism and civility need to inform every aspect of our practice, from our interactions with clients, with witnesses, opposing counsel, judges. And today's presentation will really walk through the civility and professionalism obligations that are codified in the Law Society's Code of Conduct. These are considered the minimum standards. They are obligatory. We will also look at some of the broader principles and aspirational goals that have been created by the Advocate Society. And those goals build on the minimum standards that are set out in the code. We will also have an opportunity to provide some commentary regarding some scenarios involving ethical issues, and we will highlight some of the best practices and discuss some of the issues that are raised.
So to get started, we're going to go through a few of the key provisions within the Code of Professional Conduct, starting with 7.2, which is the responsibility to lawyers and others, which is up on the screen. And basically, 7.2 speaks to courtesy and good faith. So as members of the Law Society, we're governed by this Code of Professional Conduct, and this is just an example of several explicit requirements pertaining to civility and professionalism. And I think one thing to sort out here and to point out and to flag is 7.2-1, which essentially speaks to the fact that a lawyer must be courteous and civil and act in good faith with all persons, and I'll emphasize all persons, with whom the lawyer has dealings with in the course of their practice. So moving on to some of the commentary, which is provided for 7.2, there's just a few things to draw your attention to. So there's a recognition here essentially that incivility itself is detrimental to the practice of law and the administration of justice. And so this should sort of underline all that we do as lawyers and members of the bar. Another thing that is interesting to point out within the commentary itself is this idea that we should not let any ill feelings between clients influence conduct as a lawyer. So oftentimes we are involved with very heated matters, matters which are extremely personal to our clients, and it's important that we don't let those ill feelings between our clients influence our role and our administration of our obligations under the Code of Professional Conduct. Avoiding uninformed criticism is also important, particularly with respect to the competence and conduct of other lawyers and the advice given. What's interesting also to note is it's not just limited to opposing counsel, but also speaking ill of other lawyers in the profession generally is noted in the commentary here. However, with that caveat, it's important to note that we also still need to be prepared to advise clients on complaints regarding, involving another lawyer. A final note, which I think is just common courtesy, but always good to reiterate, and it is in the commentary, is that a lawyer should agree to reasonable requests concerning trial dates, adjournments, and waivers.
So just moving on to part 2.1-1 of the Code of Professional Conduct. This section is headed Integrity. This is another requirement in our practice and in our everyday lives. A lawyer has a duty to carry on the practice of law and discharge all responsibilities to clients, tribunals, the public, and other members of the profession honorably and with integrity. Again, it's very broadly defined, so similar to what Odessa was discussing a few moments ago. It's broadly defined, it's inclusive of all individuals that lawyers have dealings with, including the courts and tribunals. When we look at the commentary that accompanies that provision, It further establishes some of the requirements for acting with integrity. It says that it's a fundamental quality of any lawyer, and it emphasizes that trustworthiness is essential in the lawyer-client relationship. Without that trustworthiness, you can understand that there would be a breakdown in the relationship between lawyer and client. It also emphasizes that public confidence in the administration of justice is an important consideration, and that public confidence in the administration of justice can be eroded if a lawyer is irresponsible in their conduct. We need to inspire confidence, respect, and trust of the clients and the general public. This commentary discusses that the requirement to act with integrity goes beyond just our professional lives, and it actually also applies to our private lives. It indicates that dishonorable conduct on the part of the lawyer, either in their private life or professional practice, can open up the lawyer to possible disciplinary action. Paragraph 4 there in the commentary indicates that generally the Law Society will not be concerned with purely private or extra professional activities of a lawyer. However, if those activities bring into question the lawyer's professional integrity, there may be a concern there.
So moving on to the next section, which is 5.1-5, which is titled Courtesy. And it stipulates that a lawyer must be courteous and civil and act in good faith to the tribunal and all persons with whom the lawyer has dealings. So again, really broadly applicable to all persons. The commentary is set just below here in the slide, and it speaks particularly to contempt of court, contempt or a lack of adherence to the professional law obligations set out in the Code of Conduct, but also acknowledging the fact that they're not identical and the fact that a consistent pattern of rude, provocative, or otherwise disruptive conduct by a lawyer, even if it's unpunished as contempt, may constitute professional misconduct. So in other words, what might constitute contempt from a legal perspective, which is, a certain level of egregiousness, is distinguished from what is expected within the Code of Professional Conduct and courtesy that is expected of all lawyers. And I think that's an important nuance to be mindful of, because it's arguably a more subtle criteria than what we would think of as contempt, and important to keep in mind.
When looking at the Code of Professional Conduct, you will see that civility shows up in various parts of the code. And we see that again under the quality of service. So civility, it not only deals with our interactions with others, but it actually deals with competency. So we look at this section, quality of service. It indicates that a lawyer, as part of that obligation to provide quality service, must be civil. That has to be read in conjunction with Rule 3.1 regarding competence. And there we see that competence indicates and encompasses civility. And it includes cultural competence and also effective communication. You can see that reflected in the commentary here.
So as Kathleen mentioned, this idea of civility is really sprinkled throughout the Code of Conduct. And there are, as we've just gone through, several sections that really focus specifically on civility and professionalism. But there are also other provisions in the code that sort of encompass or fold in this idea of civility. So we've just got a few examples here, one being 3.2-1, which speaks to quality of service again. And when it, in the commentary for that particular provision, when it speaks of examples of expected practices, you'll see there at sub 5, it talks about quality of service may be measured by the extent to which a lawyer maintains certain standards. And it provides a list, which isn't exhaustive, but one of the key examples that's provided under O is this idea of being civil. So again, we can see that civility in and of itself while it's a very broad, all-encompassing expectation and obligation of members of the bar, it's also woven into much more substantive and technical obligations that we have when carrying out services for our clients.
So up until this point in our presentation, we've really focused on the code, which again, that's the minimum standards that are expected and are non-negotiable. We're going to move in our presentation to looking at a paper that was written by the Advocate Society. It's dated February 20th of 2020. It's called Principles of Civility and Professionalism for Advocates. This was intended to focus on guidelines and principles that go beyond the minimum standards. So it's aspirational vision of the profession, which is less adversarial, less technical, more diverse, and more focused on ensuring that justice is done, while not losing sight of the advocate's duties to advance their clients' interests. We would strongly encourage everyone to read the paper, and we will highlight various duties that are set out in the paper, and then we'll have a discussion about some of the scenarios that we've come up with that we've seen in our own practices. The duties that we will highlight are listed on the screen. So you'll see the duty to the profession, a duty to the clients, duty to the court, duty to opposing counsel, which we've discussed a bit as well in the context of the code, an advocate's duty to self-represented litigants, an advocate's duty to other parties and witnesses, and then an advocate's duty of the judiciary.
So we'll start with the advocate's duty to the profession and duty to clients. So when it speaks of an advocate's duty to the profession, what the paper indicates is that advocates should be conscientious and respectful in their treatment of colleagues within their workplaces. They should show sensitivity and understanding of their colleagues' circumstances and make the workplace inclusive and welcoming. So if we tie this back to some of the pieces we've already looked at from the Code of Conduct, we can think of Section 3.1, which speaks to competence, which includes civility, or 3.2, which speaks to the quality of service. And really, this is intended to, while we have to pursue the interests of our clients resolutely and to the best of our abilities, you'll see in some of the commentary there, it speaks of, zealous advocacy is encouraged in order to do our job, but within the confines of the rules and the bounds of the law. So we have some examples if we're thinking about it, not only what we've already talked about with respect to the code. One of the things that I think is also really relevant for the territory of Nunavut is this idea of competence being inclusive of cultural competence. So the importance of not acknowledging history and the impact of systemic discrimination, for example, when we're talking about in the context of employment. So if we're from a management perspective, forming employee resource groups, hosting guest speakers on the importance of EDI topics and training, and really engaging in a practice that celebrates, differences, different cultures and backgrounds that make up a firm, for example, and recognition of those differences within the workplace. So we've decided to put together, as indicated, a couple of scenarios, and we're recording this and not doing it live, so we won't have the same vigorous discussion I know we would have in person, but we thought it would still be really useful to sort of put some of these pieces to light. So the first scenario is on zealous advocacy and setting client expectations. The scenario is up on the screen. And so basically the scenario is that we represent a client in a tumultuous family law matter. Tensions are very high, as they often are, and the client is extremely emotional. When discussing legal strategy for the case, the client insists that they've hired us to be a shark and to absolutely destroy the other side. The client insists that you refuse to cooperate with the other side and drag the matter on as long as possible to exhaust the other side's legal resources. So a couple of questions for discussion and to think about. The first being, what are ethical obligations? And the second is, how do you respond to a client who is asking you and trying to instruct you to engage in this kind of behavior? So in thinking about some of the applicable code provisions that we've already kind of gone through, the first one that comes to my mind is 7.2, or this idea of courtesy and good faith to all persons that we have dealing with. So that, of course, includes opposing counsel. So, avoiding sharp practice would be within the confines and the structure of the code, as well as the point we made at the outset, which is to not be influenced by clients' emotions. So, of course, this is a very high tension situation, but we have to be really careful as advocates to make sure that the client's emotions don't influence our behavior such that we end up offside of our obligations. One of the pieces that's also coming up here is, dragging the matter on. So while there would be a duty to accommodate reasonable extension requests, you have to manage those. And so, of course, you can't just continue to ask for extensions or drag things out in an unreasonable fashion. It's also, I think, encompassed in the general theme of the code that advocates should consult on scheduling and make genuine efforts and be reasonable with one another with respect to things like adjournments or accommodations between the parties, and that would certainly apply here. And it's also important to note that it's advocates and not the clients that have the sole discretion to determine the accommodations to be granted to opposing counsel and litigants on matters that don't directly affect the merits of the case or prejudice a client's rights. So while advocates should essentially not just accept a client's demands, that they act in a discourteous or uncooperative manner or engage in conduct that would, be unreasonable or unreasonably delay matters. So in terms of how we deal with this specific situation, I think one of the ways that we address it is to explain very clearly to our client what our obligations are. Arguably, we did not write the rules in every respect. And so we have duties as a lawyer, and it's important that our clients understand what those are and that they include this obligation to act in good faith and to be civil with opposing counsel, the opposing party, et cetera. And also that because of these rules and because of these standards and requirements, that you will not, as their counsel, engage in conduct that would either trick or unreasonably, cause delay to the other side. Setting client expectations is important from the outset to try and nip some of these particular requests or behaviors in the bud, particularly in a high stress kind of environment. But you can also do this while demonstrating to your client that you'll still be a zealous advocate and make sure that their best interests are observed. And you can do this while at the same time ensuring that you are acting civilly in a courteous manner and upholding the administrative justice in the way in which we're supposed to. I don't know, Kathleen, if you have anything to add.
No, I agree entirely with what you've said. I think it takes time to establish a reputation of integrity and trustworthiness. But one incident where you've not acted appropriately could influence and could jeopardize your reputation of integrity. And so I think it's important to make sure that we are acting reasonably and that our clients understand the limits of what we're able to be doing. We're not going to be doing something unethical. We're not going to be, just attacking at every whim. So we'll move on to an advocate's duty to the court and the judiciary. And so you'll see that on the screen as well. So it indicates that advocates should use tactics that are legal, honest, and respectful of courts and tribunals, that we should act with integrity and professionalism while maintaining our overarching responsibility to ensure civil conduct. And then there's this advocate's duty to the judiciary. And under the heading, what judges can expect from advocates, it says judges are entitled to expect that advocates will treat the court with candor, fairness, and courtesy. What does that mean to be courteous to the court, to act with candor? I mean, sometimes as advocates, we have to disclose to the court, case law that's adverse to our position in the litigation and explain why it's distinguishable. We can't just hide those kind of things. We can't be disrespectful to the court. One of the scenarios that we've looked at is with respect to social media use. A lot of advocates are using social media a lot of advocates' children are using social media and are probably more sophisticated with it than I am. So the scenario is on the screen as well. Amanda had a trial before a judge of the Nunavut Court of Justice. The trial was long and hard fought by all sides. Ultimately, the judge decided to award damages against Amanda's client. She's furious. She decides to take her anger out on Facebook and writes a status stating the following: the judge was completely lost and didn't understand the issues and should go back to law school. Kind words. The judge is biased and only granted in favor of the plaintiff because the plaintiff's family knows the judge. The post also identified the judge by name. So our question: do these comments published on the social network raise issues relating to professionalism and civility? I think it's obvious that they do. So this is one of those scenarios that falls into the category of personal lives potentially being taken into consideration when it comes to conduct. So advocates should avoid putting critical comments about an identifiable opposing counsel on social media, should avoid criticizing the judiciary and opposing parties. So be cautious in the way that you're using social media, even if your friend group is just family members or close friends. You have to demonstrate restraint there. The applicable code provisions that this raises are 2.1, dishonorable conduct in private life, and also 7.2. We, as advocates, have to recognize the public position that we hold, and we want to ensure that we are not bringing the administration of justice into disrepute. Comments that we make about the judiciary carry a lot of weight because we're dealing with the judiciary every day. So people will assume that we have some sense of what we're talking about when we're commenting on things related to the judicial system or the judiciary. Judges have a reasonable expectation that we will act with civility in court and also outside of court. And so we should be erring on the side of not posting substantive comments or specifics about our cases. Even if it's in a private or personal capacity, it can open ourselves up to disciplinary action.
Okay, so the next one is a good one. We've been talking a lot about it generally throughout the presentation so far, and that's an advocate's duty to opposing counsel. And really, in a nutshell, you can see here in the commentary, it speaks to, orderly and civil conduct of proceedings. And it actually says advocates should always act with civility, including when they engage with opposing counsel and when they're facing challenging clients, issues, conflicts, or disagreements. So a lot of the scenarios we've already talked about so far, this underlying current of a duty to opposing counsel would be on all of these pieces. This also includes individuals who are working under an advocate's supervision, whether that be a junior lawyer, a clerk, staff. All of those people should be expected to conduct themselves with courtesy and civility, and extending that courtesy to opposing counsel, balancing that with prejudice or lack thereof prejudice to the client. So, when thinking about how we respond to things, we're obviously thinking of our client's best interests, but what courtesies and what respectful behavior can we engage with opposing counsel when we're responding even on some of those really contentious issues. The other thing that I think is also important, and Kathleen alluded to it with respect to the judiciary, but it's always being honest and truthful with opposing counsel with respect to the issues, the challenges that can, one, promote the efficiency of the administration of justice in finding your way through a complicated matter much more quickly, but it also just makes it a lot easier to deal with people on contentious issues when you're honest and truthful, in addition to being courteous and civil. And it also, if you look at the bottom of the screen, speaks to courtesy and civility shown not only to opposing counsel, but also to others. You see the word others is there, so it's very broad. So while it includes, articling students or self-represented litigants, it really includes anyone with whom we engage with in the course of a matter. Another thing that I think is important to flag is it's not just in how we deal with one another in the presence of the judiciary, but rather in emails, in telephone calls, now on Teams chats or team calls. So all of those types of communication or interactions with opposing counsel, we should be adhering to these principles. And, you know, I think one of the other pieces that flows a lot from this idea of social media is avoiding acrimony or disparaging personal remarks when interacting with opposing counsel. With respect to communications with opposing counsel, you can see it speaks very broadly in the paper about not making ill-considered or derogatory or uninformed comments about opposing counsel to others, including our own clients and the court. So we have an obligation to keep that in mind when having discussions with our client about the file, or for example, the latest letter to come from opposing counsel. We need to be mindful of these obligations when we're interacting, you know, even in the privacy of a conversation with our own client. Avoiding posting critical comments about identifiable counseling on social media, which we've already talked about in respect of the judiciary, but it is a small bar, and law Twitter is a real thing. So it's important to keep that in mind. And the other thing I think that flows from that is this idea that, you know, we should not be attributing any type of bad motives or improper conduct to opposing counsel, except where it's really well-founded and relevant to the issues of the case. So there are, of course, unfortunately, times where these are real issues that we have to deal with as lawyers, but it's, you know, that should not be the default unless we have a very good reason to believe that is the case. And in that particular case, there are recourses, you know, under the law, under the code of conduct that we should be taking, as opposed to just attributing things to other lawyers in the context of social media or in conversations. So the next scenario we have involves opposing counsel and threatening counsel in particular, and the scenario is up on the screen and reads: a lawyer is acting for the opposing side and has become increasingly aggressive. Their latest email correspondence includes personal attacks against you, including the following: where did you go to law school? You don't understand anything and deserve to be disbarred. It's great to read on a Monday morning. I was talking about your position with my colleagues and we laughed at how ridiculous it was. Seriously, look out. I may complain to the Law Society about you and how you're incompetent. So the questions that we have for discussion are: does the email constitute a breach of the code of conduct? And what steps should you take if you receive this kind of correspondence? So how would you, in particular, respond to the email? So I think with respect to the first question, I think the answer we probably all felt in a gut reaction is yes, based on some of the commentary made. With respect to the code provisions in particular, I'd refer you to 7.2 in particular, 7.2-4, as well as 5.1. And really at the end of the day, the response should deal with the substance of the litigation. So there was really no basis on which the opposing lawyer should have engaged in a conversation about anything relating to, you know, your personal education, your position, et cetera, unless it has to substantively do with the issues in litigation, which I would put to all of you. None of these comments would have to do with the litigation at issue. So, you know, assuming there may have been a demand letter or a response or a counteroffer made in the letter this lawyer is responding to, they should have responded very substantively to either your offer or the position set out in that correspondence. You know, I think one of the obvious things in terms of addressing this type of behavior is to address this type of behavior and not let it go without kind of a response. And it doesn't need to be acrimonious or aggressive in return. It can simply note that that type of communication is not acceptable and that they should refrain from communicating in that manner going forward. You know, one of the questions I think that comes to mind is, say this train back and forth were to continue and counsel continued to act in this manner, you know, is there a point at which we would take additional steps other than just responding to say, I'm gonna note the manner in which you spoke to me and note that that's not acceptable and you know, arguably not in accordance with the code of conduct, but I'm going to just get on with the issues as my client deserves. But at what point would you go an additional step? So some things might be, you know, offering them the opportunity to retract or to back down. And at some point, if it got egregious, it could even mean considering the referral of the communication or of that behavior and those threatening comments to the appropriate professional disciplinary authority. If things got really egregious and we were in the context of a litigation in particular, there is a point where behavior and conduct such as this could constitute a seeking of costs. They add no value. They're arguably a waste of time to engage, and they can be used to ask the court to consider, this conduct in the awarding of costs when the matter has come to an end.
Well, and I think in rare circumstances, you see sometimes the court sanctioning this kind of behavior by counsel by making a cost award against counsel personally. Unfortunately, that does happen from time to time. You would hope that counsel wouldn't resort to tactics that are that extreme, but unfortunately it does happen. Our next scenario is dealing with obstructive counsel. You're conducting examinations for discovery of the plaintiff in a personal injury matter. Plaintiff's counsel repeatedly interrupts you before you're able to ask questions to the plaintiff, stating that's not relevant, or, oh, they won't be answering that one. You've barely been able to ask any questions without interruption, and counsel is getting increasingly aggressive. For discussion, what should you do? And where is the line between zealous advocacy and inappropriate, unethical conduct? And I think this scenario you can expand out to dealing with obstructive witnesses or evasive witnesses. How do you deal with that? We're human, so obviously it can become frustrating, it can become upsetting, but the first thing is we have to avoid responding in anger. If this is counsel that you're dealing with, that the issue is about counsel's behavior, sometimes you can go off the record. You can be aware, because usually if you're dealing with obstructive counsel at an examination, you'll know before the examination that counsel is going to be obstructive, or you'll suspect that they're going to be obstructive. So you can be armed with the applicable case law and the rules, and attempt to have a discussion about why it's relevant, or to understand the objection. Sometimes you have to put on the record the reason why you believe the question is relevant, and opposing counsel can put on the record why they believe it's irrelevant, and then you'll have to have the court determine relevance on a motion, on a refusals motion. So you may have an off the record discussion, but you probably also have to put it on the record. In certain circumstances, it may be helpful to ask for a break, speak with counsel. Sometimes, counsel are acting in a particularly aggressive manner because they're trying to impress their client or demonstrate to their client that they're being a shark in the earlier discussion. So having a discussion with counsel may be helpful. Unfortunately, I think sometimes when you're dealing with obstructive counsel, having those discussions may not change the behavior. If the issues persist, then you should, again, try to put all your questions on the record. So at least they're there, and you have all the objections, and you may have to bring your motion for refusals. If it becomes so extreme that essentially nothing is being answered, you may consider adjourning. I'm always hesitant in adjourning the examinations. I find that it's better to put all your questions on the record, so at least you have a full transcript of the questions that have been asked, and you can bring that to your refusals motion. But you can adjourn in certain circumstances and indicate that counsel's conduct has meant that the examination cannot continue. But as I said, I'm hesitant to do that. Before bringing your refusals motion, you may want to ask opposing counsel to reconsider their position, ask them to explain their position, and make efforts to try to limit the scope of the refusals so that the issues that are going before the court on your refusals motion are only those ones that you've not been able to reach agreement on. And obviously, there's the opportunity, similar to our earlier scenario about costs. Unprepared witnesses or obstructive counsel, it does have the impact of increasing the cost of that discovery. So you can be requesting additional costs in those circumstances. And if I'm doing that, I'm usually papering that. I'm putting to counsel correspondence that indicates, our concern is that our costs have been increased because of the conduct, and we will be proceeding to ask for costs, so that there can't be a suggestion down the road that, oh, counsel didn't know that, additional costs were being sought.
So the final duty or highlight from the Advocate Society paper that we wanted to raise is one that is increasing in frequency, and that pertains to duties regarding self-represented litigants, but also other parties and witnesses. And self-represented litigants are becoming really a norm in our courts and in our tribunals. We likely all deal with them with an increased regularity, and they can be challenging to deal with for a variety of reasons, including, just not having the knowledge or the technical, education behind practicing law. And it's not always straightforward, as we all know. So it can be really frustrating to deal with self-represented litigants. And it's important to note, and it's important to adhere to, and the courts expect this of us as members of the bar, to treat self-represented litigants with the same respect and courtesy shown to other counsel. And I think this includes, not just in the manner in which they're addressed, whether in court or in correspondence, but also in terms of not utilizing that particular fact to cause any, disadvantage to them, or trickery, for lack of a better term, just because we know that they don't have the substantive knowledge that perhaps we do, given our education and training. The other piece that the Advocate Society's raised is with respect to other parties and witnesses, and this goes back to what we talked about at the very beginning of the presentation, where we highlighted the fact that the Code of Professional Conduct is very broad in speaking to some of the expectations as being required to our interactions with all persons. So the Advocate Society is sort of maybe defining a little bit more what some of these common categories of other persons might be, and that includes individuals like self-represented litigants and witnesses. And you'll see here at number 69 on the screen that advocates should always be courteous, honest, and civil in communication with witnesses, and should not abuse, intimidate, or harass a witness, which seems, to many of us to be a given, but obviously it's in writing for a reason, because it's not necessarily a given to everybody. So the final scenario that we've put together speaks to the inexperienced self-rep, and the scenario reads as follows. You're representing a client in a dispute. The other side is unrepresented, and you receive an email from them regarding an upcoming motion. The self-rep provides their position in the body of the email, including facts and evidence upon which they are intending to rely at the motion. They explain that they're going to send the email to the court. So how do you respond to this email? So I think the first thing is to identify perhaps what's wrong with the email. And I think what we're getting at in this particular scenario is that the issue here is that the self-rep is proposing to all of the things that they intend to rely on in an email as the means of putting the evidence into the motion, rather than, for example, a sworn affidavit of evidence. So, those of us who are familiar with the rules would know the proper ways in which counsel are to put evidence into the court, i.e. in an affidavit form. So obviously the manner in which the self-rep has laid this out is not a proper way in which a court would accept this into evidence. In our view, I think the unacceptable approach would be to not do anything and wait until we get before the judge and have all of this figured out, because there is this email out there, and frankly, it's very likely that it will come to the judge's attention that the self-represented litigant had provided us with this email and laid it all out, and the judge will then turn to us and say, counsel, care to explain yourself? And frankly, doing it this way is really a waste of the court's time. And that's not really going to bode well if the judge is upset that we're now in a situation where he or she has to now manage this particular situation and perhaps adjourn and then come back later. And so this is an example of what we just raised, which is not that advocates should not try to gain an advantage from the fact that the other side is unrepresentative. So to the extent practicable, and again, keeping in mind our obligations to our clients to ensure we do nothing that prejudices our clients, advocates should be assisting the court, and Kathleen alluded to this in one of the previous scenarios also. So we have the ability as counsel to help the court in managing a self-represented litigant to a certain extent, obviously. And so this is an example where, you know, the easy thing to have done would have been to essentially, you know, given the litigant a bit of a heads up in terms of what the appropriate manner in which either just directing them to the right place so that they, you know, one, aren't disadvantaged, but two, we're not doing anything that prejudices our client. If anything, we're furthering the administration of justice by ensuring that when the motion does happen, everybody's shown up, everything's been put in the way it needed to be put in, and we can actually proceed on the merits with what was planned. And this way, the self-represented litigant gets a fair hearing. We've not done anything to prejudice our clients. The court's going to be happy because we can actually proceed as planned and get one step closer to the resolution or outcome of the matter, whatever that may be. So all of this does not change the fact that you are still the advocate for your client. But on the technical sort of procedural type issues, sometimes you do have to assist a self-represented litigant. And, you know, the court is generally quite appreciative that you do that. And it furthers all of the goals of the administration of justice when we engage in conduct like that with somebody who just isn't familiar with the rules like we are.
Yeah, and I think sometimes the clients can be frustrated, like saying, you know, what are you doing helping a self-rep? They can perceive it that we're assisting them. So having the discussion with the client to say it's our responsibility, and in fact, this is helping you because it's less likely that the motion is going to be adjourned or the hearing is going to be delayed because we've indicated to the self-represented party, you have to file an affidavit, and here's like the form of the affidavit or whatnot. It means that you're more likely to be able to proceed as scheduled. And then if the self-represented person still does not prepare the affidavit, you at least have that correspondence, so you can indicate to the court, you know, I did advise the self-represented party that that he or she had to file an affidavit, and I think then the court is more willing to go ahead and hear. So I think it's important for the clients to understand as well the reasons that we're doing the things that we're doing when it comes to dealing with self-represented individuals. I found it interesting that, you know, even some of the terminology that we use where we're saying my friend or the clients can be a little unnerved by that. What are you doing calling opposing counsel your friend? So having those discussions with the clients ahead of time to manage their expectations so that they're aware of some of the reasons that we're acting in a certain way. So that was it for us as far as the scenarios. Our contact information is on the screen. If anyone has any questions or comments, we're always willing to have a discussion. And we thank you again for the opportunity to join you today. Thank you.
Thank you.